Okay, this is Diesel We the People News. Alright, once again, I'm doing this without prejudice and without recourse. Alright, I'm not waiving any of my rights whatsoever, y'all. This is a video, give or take, around a year ago when Texas was talking about the 4D program and kind of laws of the state of Texas contract with the 4D. Alright, I'm probably going to stop here and there, so therefore I need to make a disclaimer. I'm not an attorney. Anything I say or do will be just my opinion. Okay, if you need one, go get one. Alright, I'm not giving legal advice. In fact, first-hand knowledge is always the best thing. So, before you get married, study the 4D, Child Support Division. Also, while you're married, both of y'all sit down, study the 4D Child Support Division. And when you get a divorce, study the 4D Child Support Division, okay? The state's attorney is not your friend, and it specifically says it's not. This is all contract between the lawyers and the states and the judge. The judge is not there for you. It is absolute 100% conflict of interest against you, and you do not have a due process or any constitutional rights. You're going to have to demand it, force it, and attorneys will not do that for you. Alright? Or if they do, there's going to be only very few who will. Alright? And it's sad to say, but that's what it is. You know what I mean? And let me get this other phone organized so we can hear it better and all that kind of stuff. It kind of went blank. Alright, let's proceed forward, do you think? It's a learning video, by the way, y'all.
The chair calls Joel Rogers. If you would please state your name, who you represent, and your position on the bill.
Madam Chair, Madam Vice Chair, my name is Joel Rogers. I'm the Associate Deputy Attorney General for Child Support Legal Services. I'm here representing...
Okay, so he's a Deputy of Child Support Division. Alright. Right there, he's already going to be against you just by that name.
the Child Support Division, and we're to testify on the bill as a resource witness if there's questions.
Okay, yes. Call on Representative Ramos.
Thank you. Currently, so if somebody is unemployed currently under child support, they apply the minimum wage presumption. So basically, it's as if...
See there? Right there. Right off the top, even from the beginning of this video. Alright? The court's allowed to do presumptions, not facts. So number one, that's already against you. They're allowed to presume against you.
That person makes $7.25 an hour, correct? And they calculate child support based on that income, that net income.
That's what courts typically do. The wage and salary presumption actually says if there's no...
That's what courts typically do. They're not going to go by facts. They're going to be able to do assumptions.
Evidence of income before the court can presume the federal minimum wage at a 40-hour work week. So most courts interpret that to almost create some sort of minimum child support for people who are not disabled or otherwise prevented from working.
So about $7.25 an hour. So if you're in jail, they're still your child support is going to continue to accrue at that amount.
If it was set at that amount,
right.
We...
Did you guys catch that? Even if they're in jail, they're still going to pay child support because they assume that you're making $7.25 an hour, minimum wage. Alright? There you go.
Right.
Part of this federal rule that's not implemented in this bill is that the Title 40 agency is required when people are incarcerated to either to start the process of modifying the child support obligation or notify them of that they have a right to have the child support modified, and we're in the process of implementing that in our agency as we speak.
Okay, so this reduces that to $6.25 an hour, whatever at $1,000 a month divided by roughly 4 weeks. It's as if somebody was making $6.25
Right.
an hour for 40 hours.
The low-income adjustment that's
Right.
in this bill, it will not impact very many cases at all. And it was a way to implement the federal requirement without impacting every child support case in Texas. Because if you did something like a self-support reserve, that essentially means you pick an amount that you don't calculate child support on. And so if you did that, it would impact everyone's child support in the entire state and could result in modifications all over the place. So this limits it to just people whose income is below the minimum wage amount. If you calculate minimum wage and you give the maximum deductions for dental support and medical support, when doing that, you're still above the $1,000 net resource amount.
Well, and I like it because I represent housekeepers and landscapers and seasonal workers who this would fit under that provision. But my biggest question is, at the $1,000 low income, what percentage of that child support typically would go to cover Medicaid expenses? So will a parent receive any money? Will an obligee receive any money if the obligor is under the low income bracket? But the state...
Look up obligee and obligor. They're very important words in the 4D.
Takes away the funding, right? They get paid the Medicaid and they get paid their medical and dental portion of it. So let's say dad's in prison and he's paying at the $1,000 low income. The state takes their portion of it, of that whatever comes to me from child support. Do I, mom, get what would be the average child support mom would get for one child at the $1,000, assuming they're on Medicaid and the state takes that part?
Well, we would only take any of the money if the
Remember that question, y'all. It's very important.
child's on Medicaid.
Right.
Then we would only take the portion that's designated for medical support, which is can be up to 9% of the gross of the non-custodial. It can be set by the court at up to that amount. In many cases, just because the non-custodial parent's low income may not necessarily mean that the custodial parent is on TANF or anything like that. So even if a custodial parent is on TANF, we only take a portion, I think it's $75 out of the check, and then we pay the rest. It's called a disregard payment, and then the rest of that money would go to the child, to the parent.
So it's not a percentage; it's a set amount.
Right.
So that set amount might be higher, a higher percentage if you're taking away from a low-income obligee.
Right. It would be a higher percentage because of the $75 disregard, but very small percentage of our cases are the custodial parents currently on TANF. It used to be a lot bigger in the old days, and then because of welfare reform, fewer and fewer of our smaller and smaller percentage of our caseload are the custodial parents currently on TANF.
Because Texas kicked them off. But okay, thank you, appreciate it.
Are there any further questions for this witness? Okay, I have a question. I certainly feel for... Yes.
I misstated something. The $75 disregard means if they're on TANF, the state will pay them the $75 and retain the rest. That's to get them to cooperate because they are...
The state would give them $75 and keep the rest for incentive. Okay, so you're paying child support to the state for them to keep the money. So that way, you can comply.
receiving a TANF grant. I misstated that. I got that backwards a second ago. Sorry
Yeah, you
about that.
did.
And just for everybody's benefit, can you repeat what TANF stands for? And then I have a question for you.
A TANF is what used to be called Aid to Families with Dependent Children. Now I think it stands for Temporary Aid for Needy Families. It's basically welfare for parents.
Okay. So I have a concern that we might have unintended consequences. How do we avoid the situation where someone is intentionally underemployed? I have seen a lot of that. I have known those mothers that could not get any payment out of the biological father. He purposely quit a really good job to pretend that he had no income, but funny thing was he showed up with a new expensive car all the time. So how
I know this is not court, but I would just say ejection. That's hearsay.
do we take care of children and those custodial parents without, how do we balance this?
Well, the current law allows the court to consider someone intentionally underemployed or unemployed. For instance, if you have a high-paying executive job and you decide to go pump gas somewhere instead, then the court can make that finding and presume the amount of income you have the ability to earn. They look at a lot of things. In fact, this bill addresses some of those things you look at when you essentially are imputing income. You can look at the
Imputing income, y'all. Okay. I know this is, by all means, I'm not saying not to take care of kids. I'm saying that the state shouldn't be involved. But okay, so let's just say I make $100,000 a year and you want to take a bunch of money out of me. Then why would I keep making $100,000 a year and work 80 hours a week when I can turn around and work 30 hours a week at McDonald's? After all, I'm not going to be able to see my money either way it goes, because we all know they overextend and get as much money out of you as possible.
job history of the non-custodial parent. You can also look at educational level, things like that. This bill doesn't do anything to that. It only says you can't consider someone who's incarcerated for more than 180 days as being intentionally underemployed.
Okay, I thought it did cover more people than just those incarcerated.
No, the change in the bill only attaches, because that was the federal requirement, that states cannot consider people.
Ejection. That's discrimination.
Who are in jail for over 180 days as being intentionally underemployed or unemployed.
Okay. Are there further questions? Okay. Then the chair calls. I'm sorry, there is a question here.
No, not a question, more of an answer.
Representative Ramos?
Oh, I'm sorry. Yes, thank you. Well, in this bill, it talks about how to define the income for a parent who is an obligor, who is not refusing to pay. So it's really good in terms of laying out the educational attainment and record of seeking work. So if you have a PhD and you have no record of seeking work, then I think that they can impute a certain amount of income that you're not making $5,000 a month, but you have a history of making that. And so the child support office would look at that. But if you're in jail and you've been there, for 180 days and you're not earning anything, then you shouldn't be charged at the $5,000 a month or whatever.
I think what the section you're referring to is the section regarding the imputation of income. It does, while it still allows people to find someone voluntarily unemployed or underemployed, it just says the court has to consider about 15 different factors before they make that determination. Basically, the federal government is starting to frown on finding income where it's not actual income. So they just want to make sure there's safeguards that the.
So the federal government is trying to enforce safeguards against impeding income to non-custodial who has no income. Sit and think about that, y'all. And by the way, who's this non-custodial and who's this custodial? Because as far as I'm aware of, lawfully there's only a dad and a mom. Legally they may be non-custodial and custodial. But that is trickery of words, by the way, y'all.
Court can consider all these different things before they decide to impute income.
Okay, so even the guy who's in jail 180 days, but he's some big CEO with big investments, so he's still got money coming in, like this would not, he wouldn't get off for scot-free.
No, he wouldn't get off because you would still be able to set, if assets or income, you could still make the finding that the person has an ability to pay.
Okay.
You couldn't say that they were necessarily voluntarily unemployed or underemployed if they were in prison for over 180 days, but you could still, if they have income that you could identify in the court, for instance, they get money every month, then you would.
If you can identify, right? This is why I'm telling people, do not volunteer your wages. Okay? I don't like income because income means profit. Alright? It's exchange. I'm going to give you labor for X amount of banknotes. That's exchange. Profit is income. Alright?
I don't think a court would lower the child support or zero out the child support, maybe not even lower it at all.
Okay, thank you. Any further questions? Yes, go ahead, Chair Nayave.
Thank you. And could you let us know if Texas does not implement the changes that are outlined in this legislation, the consequences?
Well, the worst consequences could be, the total loss of federal funding, which you stated was over the biennium would be at $482.1 million. Typically.
Listen to that, y'all. The state of Texas would lose possibly $481 million, okay, of federal aid, okay? So, when you mathematically figure this out, all your life you've been paying in taxes, okay? And the federal government, out of your taxes, is paying the state of Texas. Okay? So, whether you're divorced, whether you never been married, whether you never had kids, or if you do have kids, you are in fact paying child support in every state out of every paycheck. So they're double dipping. So they're telling wink wink non-custodials to pay child support when in fact you are and has been paying child support under the federal taxes. So they're double dipping, y'all. Just saying. Again, it's my opinion. I'm not an attorney.
If things don't happen, we jeopardize our federal funding. We'd have to really talk our way out of it, or we could get.
We jeopardize our federal funding. Now, you wonder why it's not conflict of interest? That judges and attorneys over there is trying to drain the mom or dads, who's ever the non-custodial. This is the reason why there's no 50-50 custodies, y'all. It's because somebody has got to pay in the funding. They're double dipping. Alright?
A lower amount of federal funding. So we're just trying to make sure that we retain all the federal funding that we can get, because our child support program is the number one child support program in the country by far. In terms of cost effectiveness, collections per FTE, and in total collections.
Thank you.
He's sitting there bragging about how Texas is the number one forced contract, and he's just sitting there bragging about it. We are just tickled to death how we are number one violating stealing money. Just saying.
All right, members, any further questions for this witness? All right, we thank you.
So, Texas Family Code 201.107C, okay? The presiding judge and the Title 4D agency shall act and are authorized to take any actions necessary to maximize the amount of federal funding under the 4D program. Okay, now we got to look at the key words. The key words, y'all, is they gave permission for judges, all right, to take any actions necessary. Okay, but it doesn't really define how far they can go. It says any actions necessary. So let's just go for argument's sake, and I'm going to just go way out there because I don't believe this is true and correct. But according to the 201.107C, all right, of the Texas codes, that the judge is allowed to order that bailiff to cuff you, and the judge is allowed to go down there and kick you and stomp you and all that. Okay, now they don't do that, but under what this law specifically says, any actions necessary, and it does not define how far or how little. That needs to be cleared up and defined. Okay, now again, I'm not an attorney. There may be other codes out there defining this, but under this one particular code, it doesn't say it, and that's what I'm going by on facts. Okay, so you know, they're allowed to kidnap your kids. They're allowed to come to your house, break into your house, and get the sheriff to cuff you and stuff you by threat of arms, and act. That judge is allowed to act as a mobster and telling the little dominions that you can go use any force necessary because I give an order. So think about that, y'all. Again, I'm not saying that's what they do in the courtrooms, but where does it say they are not allowed to commit fraud? It says any actions necessary. So they are allowed to lie, cheat, steal, commit fraud. And everything is E-OK under the Texas Code 201.107C. Now, there may be other codes that conflict with it, but this one particular code stands as facts, y'all. They can do anything they want. Just saying. This is Diesel with the People News. I'm not perfect at this. I'm just an average man. I'm an idiot. Okay? So don't take anything I say or do to heart. Study, research on your own. Okay? Everybody's listening to this. I am hearsay. Okay? And I'm just an average man trying to figure out my way around this corruption myself. Till next time, Diesel with People News.